Our next speaker is John Sandberg. John is a founding member of Sandberg Phoenix von Gontard in St. Louis. He's also the firm's managing partner. John's focus is business litigation. He has been named to the Missouri and Kansas Super Lawyers in the business litigation section, one of the top 50 Missouri and Kansas super lawyers in St. Louis, and is recognized as one of the best trial attorneys in the country by Best Lawyers in America in the areas of personal injury, product liability, and commercial litigation. John was recently selected for Best Lawyers in America for commercial, personal injury, product liability, construction, and real estate litigation. Please welcome John Sandberg.
Good morning. I have seen lots of mistakes by lawyers presenting corporate designees. Though I've made a few of the mistakes myself, I've learned from mistakes from co-defendants and from opponents in commercial disputes. I assume you are like me and you prefer to learn from other lawyers' mistakes instead of your own, so we'll talk about some of those mistakes. How important is the corporate designee deposition in your lawsuit? I told a friend of mine, a top plaintiff's lawyer in St. Louis, that I'd be speaking on this topic about corporate designee depositions. His response, and it really is a very important deposition and can mean whether you win and lose depending on how you handle it. The rules give you a number of opportunities to do things differently from a fact deposition. You have advantages, you get some powers you don't normally have, and you have some challenges, some limitations you don't normally have. First, and briefly, how are depositions of corporate designees different from your everyday deposition? These differences, of course, come directly out of the Federal Rule 30b-6. And these differences mean that you have more input into how well the witness performs in the deposition. You do have one serious challenge. The designee is the company, and you need to think of it in that way. This is something you keep in mind while you are picking the witness, negotiating the topics with your opponent, and preparing the witness for his or her testimony. First of all, forget what your mother said, looks do count. So contrast these corporate designees who are both from Fortune 500 companies. The first witness is the manager of a multi-billion-dollar finance program. And of course, you can see there's no sound because I just want you to look at her as an example, and you can see she's in all black, and she looks rather grim. Here's another witness, again, no sound because I just want you to focus on appearances. He's an engineer and was testifying about an engineering topic, and he kind of looks like the engineer he was. Keep in mind that you are both the producer and director in this performance. If you are familiar with the book Blink, you know that people will make up their mind about how good someone like a college professor is solely by looking at a video with no sound for only a few seconds. Lest you forget what this is all about when you're picking the witness, I will turn to the New Yorker to sum it up. And of course, in picking the witness, you need to think about projecting a caring image, and some people do not. You want a good face for the company. Another issue is the amount the witness knows about the facts in dispute. This is a tough issue. If the witness knows a lot about whatever is in dispute, the opponent can get into the area in detail and often go beyond the topic list. At best, you can object when your opponent goes beyond the topic list, and your objection, of course, is that the witness is testifying personally. If the witness knows very little about the matters in dispute, you need more time to instruct the witness on the topics. And a related issue that you should think about is if you're producing the witness who knows a lot about what happened, your opponent, of course, can take their individual deposition, and that thus you might have two opportunities for your opponent to cross-examine the same witness. Of course, as the witness is a good witness, it probably means little. And of course, you also have to negotiate the topic. The federal rule requires reasonable particularity for each topic. So argue this point with your opponent constantly. And of course, this can be a time to move for that protective order to help limit the scope of the topics. And again, another difference with the 30b-6 is, of course, you can tell the witness what to say. The rule tells you to do it. Sometimes what I have done is even with the witness written out the answers ahead of time, and of course, in that way you can decide how the witness answers should best be expressed. At times, I've given the witness to take into the deposition the written answers to the question. Now, will they get marked as an exhibit in the deposition? Of course they will, but in that fashion, you're getting exactly the answers that you need that witness to talk about. You know, because the information often in a 30b-6 is hearsay, you must give the witness what information the organist has, and personal information is not a requirement, personal knowledge, excuse me, is not a requirement in 30b-6 depositions. Normally you tell corporate witnesses, if you don't know what to say, if you don't know the answer, it's okay to say that. And of course, I'm not sure if you can read that, but what it says is, let's review what you didn't know and when you didn't know it. Of course, the don't know routine doesn't work very well for corporate designee depositions because the rule requires that you tell the designee and provide to him or her the information readily available to the organization. It is possible to say unknown for an answer, but you better be prepared to prove it because you have to show that the information was just not unknown, but unknowable. Deposition prep, of course, you know all of this, and you can only do so much prep. And of course, how do you know when you're ready? It's because the testimony is beginning to sound rehearsed, as it says there. Now, let's talk more about mistakes. And here's what happens when you don't pick the right witness, negotiate the topics, and rehearse. You know, standard questions in almost every deposition is, what did you do to prepare, and what documents did you review? Here's an example of what happens when you don't tell your designee how to answer these predictable questions. The witness is a senior VP of a large engineering firm.
Before you were deposed, I'm asking you if you looked at documents to prepare, for example, to refresh your memory about certain things or to go over certain topics that you thought you might be questioned about.
Yeah, I would say yes. Which documents? I don't know. It's just a stack on my desk. I don't look at the date. I just turn pages and look.
So you have no idea what documents you looked at?
Because I had no idea what you're going to ask me.
So the answer to my question is correct. You have no idea what documents you looked at.
Right.
So again, is that helpful with your important witness when he says he looked at documents but has no idea of what he looked at? And of course, I don't know if you noticed in that clip, did you notice a little curl in his lip? Wouldn't you love to have that, you know, for your presenting a good corporate image, to have your witness curling his lip when he's answering questions? So You should, of course, tell your witness to remember what non-privileged documents he or she reviewed. Why do you do these things? Because juries hate it when the witness, who is supposed to be both intelligent and prepared, can't remember what they did the day before. It's really just not credible. You know, one list, which again, a technique which I've done also, is give the witness either a copy of all the documents they reviewed to carry into the deposition, because these are going to be produced documents, of course, or give them a list of the Bates numbers of the documents that he can hand to opposing counsel. There are other ways that corporate rep deposition witnesses can make mistakes. So, arguing definitions, we'll take a look at another video.
Do you recall a discussion regarding intra-board divisiveness?
No.
Do you recall anything going on at the November CCC board meeting, or any other CCC board meeting, at which there were accusations being made or divisiveness coming up between or among any of the joint venture partners?
I really don't understand the word divisiveness.
Okay.
Can you put that in? I don't know who wrote this, so.
So again, arguing a definition of, in a question, of course, that reminds us all of others who've done that. And of course, there's also...
Shock you if the assumptions that we're talking about are true. That Wesley buys this item for less than $2 and charges the patients $166 for it. Does that sound right to you?
It would not shock me.
Not shock you. Is there anything that would shock you in that venue?
Objection form foundation.
Would $1,000 for a $2 item shock you?
So taking absurd positions isn't helpful either for with your witness. And then one more to put it in context. He talks about, in this coming clip, QA/QC, quality assurance, quality control, and he refers to what his group agreed to do in a contract and then didn't do it, but billed for it anyway.
Well, you can get a job done without QA/QC at all, can't you?
Yes.
All right, that's not a good way to do business, is it?
We've done it that way for, I don't know, I'll say 5,000 years. Since the Egyptians started the pyramids, I don't believe they had a program for QA/QC. Up until 1960s, all work was done without a QA/QC. So to fault a system that's been in place for 5,000 years, I'm not going to fault it.
Yeah, but you know there are a lot
Yeah,
of things
what?
that have been done for 5,000 years that we find better ways to do, aren't there?
Some.
Okay. Is it better to do a project with a QA/QC system or without?
You have to define QA/QC system to me.
All right, well.
Further mistakes. When I am taking the deposition of a corporate designee and my opponent asks no questions at the end of the deposition, it sure suggests to me that he or she has no intention of trying the case. I took 18 corporate designee depositions of my opponent in a fraud case a few years back. During those 18 depositions, my opponent asked no questions at the end of each of the deposition. After editing, I had 1 week of testimony where my opponent would have had no questions. I told the client after all these depositions that because of this, I was confident my opponent had no intention to trying the case and they would settle it. Shortly thereafter, they did, and we got our number. The rules allow in every state that you can use whatever part of the deposition you want. So think about what you would want from this witness to help your case ask those questions at the end. And of course, further mistakes is, and you should prepare your witness when the questions go beyond the topics. Of course, you can object that this is personal testimony and not corporate testimony, but you also want to prepare the witness that if it's really going into areas that are beyond the topics and he doesn't know, just to answer, I was not prepared to answer those questions because it is not within the topics. Finally, when you're in the deposition, watch what is going on, since oftentimes you might have to take action. Of course, I love this video of the witness, appearing to try to strangle herself while she's giving testimony. And again, you may have seen this before. If you don't recognize the person, this is Bill Gates, and this is, long ago now, but was the corporate antitrust monopoly case back in the 90s. And these clips are on YouTube, and there's many more of the clips. He actually went on and on doing this, rocking back and forth, and for reasons that I cannot understand, the lawyer for Lucent didn't stop the video and allowed it to go on and on. So what you should do if you're in this situation and you're the defense lawyer is, of course, you just say, I'm feeling sick, I think we need to take a break, and then you walk out of the room with your hand over your mouth. Of course, the reason why you have your hand over your mouth is so you don't scream at the witness, what in the hell do you think you're doing? And of course, success for you is with a video of your corporate designee witness. It isn't on YouTube. It isn't shown on trial.com as an example of what not to do, and isn't shown at the trial when you try the case. At the end of the deposition, you want to be able to turn to your witness and then say, you give good deposition. Thank you.